Good morning, everyone, and welcome to this inaugural lecture by Mr. Raju Ramachandran, who's very graciously accepted our invitation to be the Distinguished Professor of Constitutional Law. As the most often cliche goes, needs no introduction, but I will nonetheless proceed to introduce him, right? And particularly in this audience, you do know that Mr. Ramachandran is one of India's leading senior advocates in the Supreme Court, and may I dare say, part of a fast vanishing breed of the academic lawyer, right? And his work speaks for itself. The long line of cases and the impactful litigation that Mr. Ramachandran has done is for everyone to see, and of particular significance is his role as amicus in the 2002 Gujarat riots case, and also as amicus appointed to appear for Ajmal Kasab in the Supreme Court. And as all of you might have read, has contributed significant essays on various aspects of constitutional law, particularly, and I'm sure all of you have come across the book Supreme but Infallible, and Mr. Ramachandran is one of the editors of that fantastic collection of essays, and has also contributed an essay on public employment and service law in the Oxford India Handbook on the Constitution of India. I, of course, have had the privilege of working with Mr. Ramachandran very early on in my career when Mr. Ramachandran appeared for Yaqub Memon in the Supreme Court in the petition that was filed to challenge the manner in which the death warrant was issued for Yaqub Memon, and it is and our association has only continued since then. And I think it was a very inspiring moment for me as a young academic to see a leading lawyer taking up the case and the manner in which it was fought with the late Mr. Andhyarjuna, Mr. Tempton Andhyarjuna, and it was a very formative experience for me. So, sir, I'm so glad to be standing here and introducing you and welcoming you to Nalsar as a distinguished professor of constitutional law. We're extremely honored to have you as a part of us and part of the faculty. Thank you very much for accepting the invitation. Today, Mr. Ramachandran will be talking about an issue that has already claimed a vice president in that sense, and on removal of judges from the proceedings against Justice Ramaswamy to now Justice Yashwant Verma. Mr. Ramachandran has had an association with the Ramaswamy case, and I'm sure he'll reflect on that experience through the course of this lecture. And in an increasing environment where there is so much conversation and tension around independence of the judiciary, appointment of judges, the challenge to appointment of judges, and also now this context of impeachment, there is a lot to unpack and a lot and to be aware of the broader context in which this impeachment proceedings is likely to take place. And of course, it's a very, very naughty, with the K, naughty, not the other naughty, right? A very naughty constitutional issue. And I'm sure we'll listen to why it is particularly naughty, given where the proceedings are in the Supreme Court and where the proceedings are in Parliament. Of great contemporary relevance, and I don't think it's an issue that is going to go away soon, and the broader context is only going to get more complicated. So thank you so much, sir, for agreeing to come down on such short notice and deliver a lecture of such contemporary relevance. Before I invite Mr. Ramachandran to deliver today's lecture, I would like to ask Dr. Malvika Prasad to just introduce the lecture series of what is being planned as part of the lecture series today and over a longer period of a week later on in the semester. Just to give what the foundational idea and approach to the lecture series is. Dr. Prasad, over to you.
Thank you, Anup, or as I should say, Professor Surendranath. Thank you, everybody in the audience, Professor Rao, Professor Vasanthi, Professor Ram, and hello to Mr. Raju Ramachandran. It's so nice to see you in Nalsar as our distinguished professor of constitutional law. This lecture series is organized around the theme of reflecting on the structure and relationships laid down in the Constitution. What do we mean by this? These are terms that we're not commonly used to hearing in Indian constitutional law discourse, but these are terms that were popularized by Professor Charles Black, an American constitutional law professor who was at Yale and Columbia. And the first time he introduced them at length were in his 1968 lectures titled Structure and Relationship in Constitutional Law. Now, Black attempts to offer a method of constitutional argument, and as students of constitutional law, we're all familiar with two very popular methods. One is the method of reasoning from constitutional text, and the other is, in common law countries, method of reasoning from precedent. But Charles Black offers us another way to think of constitutional argument, and that is from structure. He describes it as a method of inferring constitutional principles from structures and relationships that are created by the Constitution, whether in some part or in all its parts. So, like textual reasoning, structural reasoning also requires us to read the text quite closely. But unlike textual reasoning, it entails reading not only the text that confers powers or imposes prohibitions on various state actors and people, it also requires us to read text that we might otherwise skip over, which is text that just establishes structures and relationships. So one example of that is the very first article of our Constitution, which says, India, that is Bharat, shall be a union of states. Simple article, few words, very pithy, but it lays down the structure of the entire Indian Union and mandates that it shall, in their relationships, be a relationship of union and states. A lot can be discerned from this one article that we don't commonly think about in case law. For instance, can India ever become a single union? Right? By structural reasoning, a single union with a single territory, no states, perhaps not. Right? So that's the kind of reasoning that Charles Black attempts to introduce us to. So why study structure? For Charles Black, the answer is quite simple in his lectures. It's that the method makes practical sense. Unlike, say, textual interpretation, which sometimes entails a little bit of acrobatics. In his words, he says that textual interpretation has to be made to make sense through devices of interpretation. Others, like Philip Bobbitt, have argued that actually structural reasoning leads to vastly different outcomes than doctrine. And for that reason, it's important to look at structure because it can tell us something pragmatic and useful about what the Constitution sought to lay down. So for instance, with the Article 1 example, Article 1 makes quite clear that India could possibly not ever be a union of a single territory. Whereas if you go through the doctrinal reasoning offered by case law in Articles 3 and 4, you might be able to persuade yourself that it's possible to degrade a state entirely into two union territories or reduce all states into union territories. So the doctrine leads to one outcome, the structure seems to suggest a different outcome. Now, it's one thing to study structure and relationships laid down by the Constitution from the text of the Constitution in a classroom or in a university. But I think it's quite another thing to study it in action when it unfolds, when a state actor makes a claim to power to defend state action. And this is a rare opportunity for us to do the latter because Mr. Raju Ramachandran is now going to be a distinguished professor at the university. The first lecture today will spotlight the structure and relationships between judges of the Supreme Court vis-a-vis the Union Executive and the Parliament. The specific context that Mr. Ramachandran is looking at is inquiry and impeachment proceedings, but his lecture, and I've had a chance to read his work on this, actually gets into the larger sort of principles that emerge from the structures and relationships laid down in Article 124 of the Constitution. So a quick perusal of Article 124 would be a good way to preface this lecture. So I'll just briefly leave you with that. Article 124 is titled Establishment and Constitution of Supreme Court. And if you read it, it establishes a few key relationships. One is it establishes that there shall be a Supreme Court of India and it shall have a minimum number of judges until Parliament lays down otherwise. But once you move past that sub-article, it lays down a few key relationships. One, that the Supreme Court will be comprised of judges who are appointed by the President after the President consults such other judges as are laid down in the provision. 2, that such judges cannot be removed from office except by an order of the President, and that order of the President must follow a Parliament's address. That Parliament's address must be supported by a special vote, that is a majority of the total membership of the House, as well as a majority of 2/3 present and voting. And that address must be presented to the President in the very same session of Parliament. And this entire address must be carried out on the ground of proven misbehavior or incapacity of the judge. So the relationship between the President, the Parliament, and the judges is encoded in Article 124 in this fashion. Now, from these relationships, Professor Charles Black would have us infer constitutional principles if we were to engage in structural constitutional argument. And in today's lecture, Mr. Ramachandran will teach us how to identify 2 such principles from Article 124. So without further ado, I would like to hand the floor over to Mr. Ramachandran, NALSA's distinguished Professor of Constitutional Law. Thank you very much, sir.
Yeah, thank you, Malvika, and very much looking forward to hosting you on campus later on in the semester when Mr. Ramachandran is back. So the lecture will be for about 45 minutes, and then we'll have questions for another 45 minutes. Sir, over to you.
Good morning, Professor Devarao, Professor Vasanti, Professor Surendranath, and other distinguished faculties, students. First of all, a big thank you for accepting me in your midst. I am honored, I'm excited, and honestly, a bit nervous also today. But it's wonderful to be back here at Nalsar. I've had 2 memorable programs here in the past. Many years back, Mr. Shyam Devan and I debated the basic structure doctrine here. Then some years later, I spoke along with one of your distinguished alumni, K. Parameshwar, on the Sabarimala case. So I'm proud to be associated with at least 3 of your distinguished students, senior most being Professor Surendranath, then Parameshwar, and now Malvika, who is de jure, of course, teaching assistant, but de facto teaching partner, and can I also call her teaching Sherpa, to borrow from G20 terminology. So let's start with the topic of the day, removing and disciplining of judges under the Constitution of India. Until the Government of India Act 1935, judges held tenure at the pleasure of the Crown. So there was no safeguard at all. It was akin to hire and fire. It is the Government of India Act 1935 which introduced safeguards in terms of tenure. And what is not commonly known is that in the 3 years between independence and India becoming a republic, we had the first case of what can loosely be called impeachment, where a judge of the Federal Court of India, Justice S.P. Sinha, was removed from office after an inquiry by the Federal Court. And that order of removal was passed by C. Rajagopalachari, Governor General of India. So in the history of impeachment, that would perhaps be the first post-independence case. Then comes the Constitution. Malvika has already pointed out the relevant constitutional provision which embodies two cardinal principles. One, judicial independence, because it says no judge shall be removed except by so and so, so and so. So one primary principle is judicial independence. The second is ability, because the judge can be removed by the process prescribed, loosely called impeachment. So that embodies the principle of accountability and that it's ultimately political accountability. Let's keep that in mind. It's an address by Parliament. There has been some territory grabbing by judges here, but otherwise it's a political process. Let's keep that in mind. Now, Article 124 says that the procedure shall be as prescribed by Parliament by law. So this is 1950, the Constitution. The Judges Inquiry Act comes only in 1968. So for 18 years, there's hiatus where, though the Constitution provides for removal of judges, there was no mechanism for removal of a judge. So, had no situation cropped up in 18 years that Parliament had to wait for so long before enacting this law? The answer is no. A situation did crop up in 1964. And there, the ground involved was not misbehavior, but incapacity. So, a senior judge from Patna in the Supreme Court, Justice Jafar Imam, was by seniority to become Chief Justice of India in 1964. But unfortunately, he was incapacitated in his judicial functioning by mental illness, which was not as sensitively treated in those days as it is today. So expressions which are used in that time cannot be used today in the context of describing someone's illness. But that posed a dilemma. But how could he have been removed if there was no procedure for removal prescribed by law? So it is recorded in Setalwad's autobiography that no less than Prime Minister Jawaharlal Nehru met Justice Jafar Imam and persuaded him to step down. And that's how this awkward constitutional situation, where a judge could have been removed for incapacity, but there was no mechanism, that was got over. And Justice Gajendra Gadkar became Chief Justice of India a few months before he would have otherwise become the Chief Justice of India. And that perhaps is the background or the urgency for enactment of the Judges Inquiry Act 1968. Now, first let's see the surrender by Parliament to the judicial process with the very enactment of this act. Because Article 124 gave Parliament power to regulate the procedure by law. Parliament could have very well chosen to appoint a parliamentary committee. After all, this is a public political process. Parliament could have chosen an appropriate forum, an appropriate mechanism. But Parliament, in its wisdom, and I would say in its fairness also, decided to bring in the judiciary by saying that once the motion is admitted by either the Speaker of the Lok Sabha or the Chairman of the Rajya Sabha, a committee shall be constituted comprising a sitting judge of the Supreme Court, a Chief Justice of a High Court, and a distinguished jurist. So Parliament was keen that a proper judicial process be followed to give a judge a chance to defend himself or herself. But this 1968 law remained in a state of disuse till 1991, when the Ramaswamy case came up. And it is my good fortune that as a young lawyer, I was associated with India's first impeachment as counsel to assist the Justice Sawant Committee, which inquired into charges against Justice Ramaswamy. The committee was Justice P.B. Sawant of the Supreme Court, Justice P.D. Desai, Chief Justice of the Bombay High Court, earlier he was Chief Justice of the Calcutta High Court, and Justice O. Chinnappa Reddy, a retired judge of the Supreme Court, as a distinguished jurist. And we had two eminent senior counsel of those times, Mr. Fali Nariman, of course, and Mr. Rajendra Singh, an ace criminal lawyer from Jabalpur, to assist the committee as senior counsel. Now, before this in-house committee was prescribed by the Supreme Court in 1995, the Supreme Court had constituted an in-house committee to go into the charges against Justice Ramaswamy, headed by 3 judges. And those judges had given him a clean chit. But that report was never released. Now, the Sawant Committee went into the charges in detail. Interestingly, Justice Ramaswamy did not choose to directly participate in the proceedings. Petitions were filed by one Mr. M. Krishnaswamy, MP, claiming to be a friend of Justice Ramaswamy, and also by Justice Ramaswamy's wife, Mrs. Sarojini Ramaswamy, in the Supreme Court, questioning the procedure of the committee, asking for a report of the committee, etc. But Justice Ramaswamy himself did not participate in the proceedings. The participation was through proxies, through advocates groups from Tamil Nadu. And I must also share something interesting with you, that this also at that time, this is how politics also gets mixed, partly inevitable because of the political process. The charges in retrospect against Justice Ramaswamy were relatively trivial considering what we hear of today. That is, that as the Chief Justice of the Punjab and Haryana High Court, he had gone from Madras, which was a presidency high court. And I must tell you from experience that judges of the Madras High Court are particularly proud of its being a presidency high court. I don't hear Calcutta judges and Bombay judges saying this so much, but Madras High Court judges say we are a presidency high court. So Justice Ramaswamy felt that the Punjab and Haryana High Court in Chandigarh was not grand enough. Maybe the Punjab High Court of Lahore would have had old traditions, but the new High Court in Chandigarh didn't have those traditions. For instance, silver mace. There was a person with a sash holding a mace preceding the arrival of a judge. All that grandeur was not there. The Chief Justice's house was not properly furnished in terms of curtains, etc. So the Chief Justice believed that as the head of the institution, he had enough power to introduce things like silver maces and to buy quality furnishings for the house. That was the subject of the inquiry. Now, because of the relative triviality of the charges, like when Indira Gandhi was unseated by Justice JML Sinha for misuse of government jeeps, etc. The New York Times said she was unseated for something akin to a parking offense. So therefore, these were the nature of charges. And then it became a South-North issue. And there was a feeling among members of parliament, among members of the bar, that a judge from South India was being fixed because he had offended some lobbies, and that this was something set up. And as a Tamil-speaking lawyer assisting the committee, appeals were made to me, emotionally also, that can you see the plight of a fellow Tamil? Please advise the judges whom you are assisting to be reasonable. But all that is an aside. The committee returned findings going strictly by evidence, and the evidence was made out that he had exceeded his powers, that he was guilty of financial indiscipline. And so a report was submitted to Parliament. And then politics came in again. The impeachment motion was defeated only because the Congress party in the Narasimha Rao government, though not big enough to constitute a parliamentary majority, by abstaining, it could still ensure that the 2/3 majority necessary for passing this motion of impeachment was not there, and that's how the motion fell through. Then, after a lapse of many years, 2 other cases of impeachment reaching Parliament were the cases of Justice Dinakaran and Justice Soumitra Sen. Justice Dinakaran resigned at an earlier stage, though the matter had reached Parliament. Justice Soumitra Sen resigned at an intermediate stage after one address by Parliament. But therefore, till today, there has not been a parliamentary impeachment resulting in the ouster of a judge. In the meantime, in 1995, in Ramachandran Iyer's case, which arose out of allegations against the then Chief Justice of the Bombay High Court, Justice A.M. Bhattacharjee, who was accused of corruption through a device of entering into a publishing contract where his lectures were to be printed in book form at extraordinarily high rates of remuneration. Bombay Bar had protested, etc. Ramachandran Iyer went to court. And then the court, by 2-judge judgment, so we have this in-house mechanism is something which we are hearing of so frequently today, but that has been created by a 2-judge bench decision of the Supreme Court, and that has become the law of the land as to how the judiciary seeks to self-regulate. But we must ask ourselves, is this not an encroachment? Is it not turf grabbing? If the Constitution envisages removal of a judge through a political process where MPs sign requisitions, where is the scope in the Constitution for this self-regulation, in-house procedure coming in? And let us just pause and reflect on one more thing. The judges under our constitutional scheme can only be removed. There is no lesser form of punishment which either an IAS officer or a bus conductor will be liable to, because the various forms of punishment, apart from dismissal, can be removal without stigma, reduction in rank, stoppage of increment, stoppage of pension, etc. There's no question of any lesser punishment. A district judge can face loss of increments, non-promotion to super time scale, etc. But a high court judge can only be removed from office. So what is the self-regulation we are talking about? If an in-house inquiry finds a judge guilty, what can be done except a moral censure if it is not grave enough? But the Supreme Court has decided over the years that if a judge does not resign in spite of being found guilty by an in-house procedure, then the judiciary will recommend impeachment to Parliament. Now just see the inconsistency, the anomaly. On the one hand, you do turf grabbing by saying you will conduct your inquiry. I must also add as an aside that there is lack of transparency in terms of the reports. So the in-house inquiry into Justice Ramaswami was never made public. Very recently, the in-house inquiry into the charges against Chief Justice Ranjan Gogoi were not made public. Now, both these reports were reports of exoneration. So, if a judge who's facing allegations has been exonerated, then what is the secrecy about making the report public? Would it not enhance the confidence of the public that someone has gone into it? But strangely, these reports have been kept back. On the other hand, now very recently in the case of Justice Yashwant Verma, the report has become public. And so the judge has been tried already. Now coming back to the court then recommending impeachment. There was a judge of the Allahabad High Court, Justice S.N. Shukla, in whose case the Supreme Court recommended impeachment. Justice Deepak Mishra was the Chief Justice at that time, around that time. Parliament just ignored it. Nothing happened. Justice S.N. Shukla is retired. There's a CBI case. But this recommendation by the Supreme Court to impeach was not taken seriously at all. Now let's come to two recent instances. One by Justice Shekhar Yadav, a speech by Justice Shekhar Yadav of the Allahabad High Court. An incendiary speech, a volatile speech. The collegium called the judge first to ask him for an explanation. He refused to apologize. Then he said he would apologize in due course, etc. Nothing happened. Then we didn't know what, because at one stage there was great transparency because it became known that the judge was called. After that, we were left guessing about what happened. Has the Supreme Court lost interest in the matter or what? Then it transpired that because a motion had been moved before the chairman of the Rajya Sabha, in the case of Justice Shekhar Yadav, and by the way, the signatures are still being verified of that motion against Justice Shekhar Yadav. But the Rajya Sabha Secretariat writes to the Chief Justice's office saying that now, because the matter is in season, as it were, of the Rajya Sabha, you don't have jurisdiction, so don't proceed with the in-house inquiry. So a political process has started, and that was political because MPs signed. And on a personal note, I also instigated a few MPs to sign. So there was no in-house inquiry or anything. The speech was so brazen. Such a judge should not be sitting on the chair. But that was the reason. So on the one hand, the Rajya Sabha says to the Supreme Court, don't go ahead with your in-house inquiry. On the other hand, the Rajya Sabha is sitting on the motion because till today the signatures have not been verified. Apparently one member has signed twice. So that is where that is. So in-house procedure doesn't matter at all as far as that case is concerned. And no, you can't self-regulate now, it's with us. And we may sit on it, whatever. Now come to the case of Justice Yashwant Verma. So an in-house inquiry is held. It finds him guilty. And so the court writes to the political executive recommending impeachment. And therefore, a political process, just see what a mess and a mix-up this is. A political process now starts on the recommendation of the judiciary. And now you've seen the recent credit grabbing exercise, which has led to the resignation of the vice president. So it was the government which wanted to be in the forefront of checking judicial corruption. So the government wanted to be in charge of sponsoring the motion. And it was the Parliamentary Affairs Minister who reached out to opposition MPs, asking them to sign. And they all willingly signed, all those who were approached, because nobody would want to be seen as developing cold feet when there was an issue of corruption in the judiciary. But then, because the chairman of the Rajya Sabha received a motion signed by opposition MPs for the same thing, the government was annoyed with him, and the resignation drama has played out because the government wanted to be seen as the mover against judicial corruption. So it felt its thunder had been stolen by this opposition-sponsored motion, which, to the best of our knowledge, has not been admitted so far. Because accepting in your office, either through your secretary or because senior political leaders are coming as a courtesy, the vice president receives them in his chamber and says, yes, please give it to me. This still doesn't amount to admission of a motion, which is a quasi-judicial process where the chairman of the Rajya Sabha or the speaker of the Lok Sabha applies his or her mind and says this is a fit case or not a fit case. For instance, in the case of Justice Deepak Mishra, against whom also there was a motion spearheaded by Mr. Kapil Sibal, the then chairman, Mr. Venkaiah Naidu, passed a detailed order rejecting the motion. So it was dismissed at the threshold like an SLP. But as an aside, again, I may say that it looked almost as if this order was being prepared in advance, because the time gap between the submission of the motion to Vice President Venkaiah Naidu and the rejection with a detailed speaking order was only 2 or 3 days. So it looked as if it was a kind of a cooperative effort. Now coming back here, today is Saturday. On Monday, Justice Yashwant Verma's petition challenging the report of the inquiry is listed for admission before the Supreme Court. Now, let's consider this. the entire basis of the motion in the Lok Sabha for the removal of Justice Yashwant Verma is the in-house committee report. It is not that parliamentarians have independently collected material. This in-house committee report has been sent to the government. The government has sought signatures all around. So the whole basis is this in-house report. Now, just assume theoretically that on Monday, the Supreme Court finds some merit in Justice Yashwant Verma's petition and stays the in-house report. These are all theoretical possibilities. But if that report gets stayed, then doesn't the substratum of the impeachment motion, doesn't that go? Because it is solely based on the in-house inquiry. So these are the kind of contradictions which happen when in-house extra-constitutional mechanisms like in-house inquiries are introduced. And the court says, if a judge doesn't comply with our request for resignation, then we will invoke the political process. What else is that? Does the Constitution contemplate such a situation where the judiciary will invoke a political process? This is, of course, a lacuna in the Constitution itself. But we are dealing with the Constitution as it stands. And so, what we have before us in the next few weeks is a totally messy situation where which view is going to prevail? Is it the view of this in-house committee, which perhaps may not be stayed by the Supreme Court, which will lead to the motion going ahead? But please remember, the in-house procedure is still not the last word, because Justice Yashwant Verma's conduct is yet to be inquired into by a committee under the Judges Inquiry Act. Let's not lose sight of that fact. This is only prima facie. So if the Speaker of the Lok Sabha appoints a Supreme Court judge, a High Court Chief Justice, and a distinguished jurist, and they come to findings completely contrary to the findings of 3 judges of the in-house inquiry, we are faced with a Ramaswami-like situation in reverse. In the Ramaswami situation, the Justice B.C. Ray Committee found Justice Ramaswamy innocent of the allegations or charges, but the Justice Sawant Committee found him guilty. This is the reverse. The Justice Sheel Nagu Committee, in-house committee, finds Justice Yashwant Verma guilty, or at least in this context, let's say prima facie guilty. But the committee appointed under the Judges Inquiry Act could find him not guilty. And under the Act, if the committee finds him not guilty, that's the end. 100 MPs, 200 MPs doesn't matter. If this judicial committee finds him innocent, that's the end of the political process. So there are interesting days ahead. Thank you all for your patience. I will just end with one more personal anecdote relating to Justice Ramaswamy. So the impeachment story ended then in 91, 92. And once the motion had fallen through, Justice Ramaswamy, with his own sense of honor, decided to resign. He had faced all this, but he felt he had been vindicated now because the impeachment motion had fallen through. And he decided that now the honorable thing to do was to quit on his own terms, and so he resigned. Many years passed. Justice Ramaswamy is leading a retired life in Chennai. I have moved on in my life and career. I became a senior advocate in due course. I became additional Solicitor General. And when I ceased to be additional Solicitor General after the change in government in 2004, I was looking for a suitable premises for my office because my house was being remodeled at that time. So I needed something for a stopgap period of 2 years. So I asked lawyer friends to look around, and someone came back to me and said, so-and-so property is available. It is owned by Justice Ramaswamy. What is your relationship with Justice Ramaswamy? I said, I never knew Justice Ramaswamy personally. My only relationship has been that of an adversary in the sense that I was counsel. But please go and ask him. I am sure he will not refuse. And that is what happened. He said he was quite willing to give it to me. Then I spoke to him. He blessed me. He said, God be with you, Raju. So that was the greatness of the man also, that he knew that I was only doing my professional role, and he had no hesitation in accepting me as a tenant. So I thought I should end this talk with this heartwarming story of human goodness. Thank you so much.
Was the house well furnished? No, thank you, Mr. Ramachandran. Such an interesting setup, and I think at least for me, I hadn't thought of it in the manner that you have presented it, and the kind of potential complexities we're likely to wade into in the coming weeks. So I'll open up the floor for questions. Yeah, just identify yourselves and just keep the questions short so that we can get in as many questions. We are at 10 past 12, I think. Yeah. So we are at 10 past 12. Maybe we can go till 12:40. Yeah, we'll take 30 minutes of questions. Yes. Yes. Yeah, Aditya. Yeah.
Hello. Hello, sir. I'm Aditya. I study in the 4th year here. My question was that, like, I got a perception from your talk that you were in defense of the Judicial Inquiries Act, or whatever the relationship was enshrined in the act between the parliament. So basically, for the initiation of an impeachment motion against a judge, the field was occupied by the political actors, whether it is the legislature or at the point of admission of a motion in the house of the Rajya Sabha chairman and dare I say that in India, these have overtly become politicized. So my question was this only, that whether this whole thing should lie in the area of political actors, even though we know that the legislature has democratic legitimacy. There could be a possibility that a judge which is denigrating the integrity of the judiciary in a manner, but there is unanimity in the political actors that he or she should not be impeached, and there it could cause a a fight between the two institutions where the judiciary sees that, okay, like in case of Justice Shekhar Yadav, we know that the judiciary saw it as the denigration of its integrity. But if there was a political unanimity that Shekhar Yadav should not be impeached, then I don't know, like it causes an anxiety in me. So do you have a solution for it?
Okay.
The drift of your question, as I get it, is first let me clarify. I was in favor of the Judges Enquiry Act in the sense that it is part of the political process itself, because the political class in its wisdom has decided to be fair by conducting its inquiry through a forum like this. What I am not in favor of is this in-house inquiry system at all. Now, with reference to your specific question which you're asking in the context of Justice Shekhar Yadav, the judiciary has felt that this is serious enough for the judge to be removed from office. Now, the judiciary doesn't have the power to remove by itself. And I don't think the judiciary should ever have that power, because there must be external checks and balances for every institution. And in our constitution, there is a system of checks and balances. So just as judges can be extra fair to themselves, that they may protect each other, equally it is possible that judges can be unfair to one of themselves in order to protect their shining image. Therefore, there has to be an external factor. Now, the political process has started in terms of an impeachment motion being submitted with a requisite number of MPs to the then chairman of the Rajya Sabha. It is just that at that time, that particular individual chose to take his time to verify signatures. He became proactive later when it came to Justice Yashwant Verma. But ultimately, it's a question of who are the individuals in charge who are holding high constitutional office. That is always unpredictable, but I would still submit that the present process of parliamentary removal should stay, because it protects the judges also. On the one hand, truant judges can't get away, but at the same time, it protects judges also because it ensures a judicial inquiry, and the constitution envisages a 2/3 majority. What greater protection can a judge enjoy than that?
I had a follow-up.
So, we'll just. Any more questions? Yes. We'll take 2 questions.
Good.
Yeah. Yeah. Is that okay?
Yeah.
Yeah. We'll take 2 questions now. Yeah.
Hello, sir. I am Priyadarshini. I am an LLM first year student. Sir, I often wondered, why are we intertwining judiciary and the parliament now that when a judge, due to his misconduct or misbehavior, he is being impeached? And we form a committee, we form an internal committee, we form an inquiry committee. And then if the judge is not really, paying heed to the judgment that he must be impeached, why are we taking it to the parliament? Why are we intertwining a judicial process into a political process where the Lok Sabha and the Rajya Sabha is getting involved when the motion is passed? Why are we having a mixture? I mean, now that we find, of course, we can have a mixture, but isn't there a limit? I mean, aren't we drawing a line? Aren't we an independent body? Why do we need a political process intertwined at all?
Okay, I'll answer that after the next question, because we're
Sure.
taking 2 questions.
Sure, sir. Sure.
Please.
Thank you, sir, for the talk. Sir, in your talk, you have
Just
highlighted.
introduce yourself.
Oh, I'm sorry, sir. I'm Masad, a BLLB student here at NASA. So, in your talk, you have highlighted some interesting contradictions within the process of Justice Yashwant Verma and Justice Shekhar Yadav. And you have said that if on Monday the inquiry report is stayed, then what will happen? Like there's gray area. But sir, in the case of Justice Shekhar Yadav, the parliament initiated the impeachment motion without an inquiry report. So cannot the parliament, even in the absence of an inquiry report, can initiate its motion for impeachment? And there is no like reason for impeachment report to be there for parliament to exercise its power. Thank you,
Yes.
sir.
I'll answer in the same order. Now to your question as to why the political process should be there at all. The answer is because that's how the constitution is today. If what you're suggesting is that a judge's internal inquiry, if it finds someone guilty, then the judiciary should be able to deal with the judge by itself, would require a constitution amendment by which maybe something like a Supreme Judicial Council or something is introduced, and judges can sack themselves. It's an interesting thought, because if judges can appoint themselves to the collegium, why can't they sack themselves also? That's an interesting thought to debate. But as the constitution stands now, it can't be done. But I would personally still be in favor of an external element. Because after all, these are three great wings of state: the executive, the legislature, and the judiciary. And the constitution runs on the principles of checks and balances. And the judiciary may protect itself, but it's possible that the judiciary may be unfair to one of its members. And in the case of Justice Yashwant Verma, some of us have felt that in making some things public in the name of transparency, the judiciary has been unfair to Justice Verma. So therefore, a parliamentary check with the safeguard of 2/3 majority, I think in the larger context is desirable. And I think the constitution makers were wise in bringing parliament into the process. And you can see that parliamentarians are not bloodthirsty about removing judges. If in all these years not one judge has been removed through a parliamentary process, why can't we trust parliamentarians? And your question was that irrespective of this in-house inquiry, yes, let me answer it with reference to the two cases which are present before us today: Justice Shekhar Yadav and Justice Yashwant Verma. In Justice Shekhar Yadav's case, there's no in-house inquiry at all. So if and when the signatures are verified, and if among you, any of you is a good handwriting expert, you can also volunteer, because it seems to be taking so long to verify those one or two questions. If and when that is done, then it will be an inquiry under the Judges Inquiry Act without any in-house inquiry preceding it. And that will be a proper process, right? But in the case of Justice Verma, you're right. If this report gets stayed, the question I asked is only whether the substratum is lost or not. But once the motion is admitted, even if this in-house is stayed, nothing stops Parliament from going ahead through the proper process of in-house inquiry, etc. So that will go on without reference to this in-house inquiry. And another interesting question I want to pose. Let's assume this in-house inquiry is not stayed, it stands as it is. And before the inquiry committee under the Judges Inquiry Act, the report of this in-house inquiry is also cited. How are those judges going to react to this? Will they, because of judicial committee, these are all their own colleagues, treat it with utmost respect? If they find it full of glaring anomalies, will they be able to condemn it outright? Or will they just say, this is something entirely different, we are not bound by it, this can at the most be said to be a prima facie view? We are going to see all these interesting situations shortly.
Mr. Ramachandran, can I ask that, isn't it into sort of looking at what Malvika was saying in terms of structural arguments, isn't the introduction of a in-house inquiry a check and balance system? Yes, it is a judicial innovation and we might worry about what is the source of where the process is coming in. Isn't it an interesting check and balance system so that it is not subject to the political vagaries of the time, that like in a Justice Shekhar Yadav kind of situation, what may happen there or not happen there is subject to political realities, political alignments, all of that. Whereas you have another system, for whatever it's worth, you can't remove a judge through an inquiry, but at least there is that moral condemnation or that public assessment of what that judge said or did. And in that sense, isn't that check and balance an important feature to have? One. And two, on going back to the question on what if there were a motion were admitted by the chairperson of the Rajya Sabha and there were absolutely no underlying material, right? Let's assume that. I would assume we would be skeptical of any judicial review of that decision to admit that motion, right? Or even if it would be, even if the requisite numbers came together and decided they didn't like a judge for whatever reason, right? And it could be ideological alignment, it could be that they're coming in path of what the government wants to do, and a motion is admitted purely without any reasonable basis. I assume you would agree that even then, there is no scope for judicial review of the decision of the chairperson to admit that motion, right? Yeah. So just
let me answer your question in two parts.
Yeah.
First is when you say that though it is self-created,
yeah,
it is a good check and balance.
Yeah.
You are right to the extent that the judiciary is introspecting through this process even before anyone goes to the political class. So the fact that a peer group is looking at one of its own is definitely something good and healthy, though ultimately it doesn't lead to anything because there's no power ultimately to act on it. Now coming to the second part of your question, it's interesting. This is gray area. The speaker, of course, has to apply his or her mind to decide whether there's material to admit the motion. It can't be admitted for the asking, right? Yes. But as experience has shown, starting from Ramaswamy to Dinakaran to Soumitra Sen, there has always been material, painstakingly researched material, sometimes by leading lawyers. For instance, in the case of Justice Dinakaran, leading senior advocates of the Madras High Court were involved in the exercise, and it was unanswerable. So, in the instances so far, there has not been an instance of a motion being admitted on a mere asking without a say-so, on a mere say-so. It doesn't happen. That's right. That's right. Now, as far as judicial review is concerned, this has not come up before the Supreme Court, though in the context of the Ramaswamy case, there were other aspects of judicial review which came about. One was whether a motion to impeach lapses in spite of an inquiry committee having been set up, because Justice Sawant committee had been set up by then. But then the Lok Sabha was dissolved. So the government of the day, the new Narasimha Rao government, decided that everything was over. The motion had lapsed. The Sawant committee had become functus officio. The Supreme Court said no, it is not. So that was one instance of judicial review in the impeachment process. Then it was clarified in the triad of cases, subcommittee, and then M. Krishnaswamy and Sarojini Ramaswamy, that while the proceedings before the speaker would be quasi-judicial and the committee's proceedings were quasi-judicial. So for instance, if the Sawant committee had passed an order in clear breach of the rules of natural justice, then Justice Ramaswamy at that stage could have gone and challenged it even under 226 or 227, because the Ramaswamy Sawant committee was a tribunal. The Supreme Court also goes on to envisage a remedy, though the question hadn't come up. The request in Sarojini Ramaswamy was for a copy of the report. That the Supreme Court negatived, saying that that report will only go to Parliament. But if Parliament passes a motion for removal, then that will be subject to judicial review on permissible grounds. Now that was in anticipation. Courts don't decide academic questions, but they did. They gave protection to Justice Ramaswamy by saying, if at all you're removed, you come to the court and we'll see if we can right. But what has not been decided is the answer to your question, whether the order of the speaker or the chairman of the Rajya Sabha to admit or not admit a motion is challenged on the grounds of lack of material. Is there judicial review? That's an unanswered question.
Good afternoon, sir. Myself, Akash Mishra. I'm an LLM first sem student. Sir, I always had this thought of a peculiar case of Justice A.N. Ray, Chief Justice, and the way I have interpreted his behavior and everything. The basic structure or the constitution mandate, I always thought that was somewhere violated. We don't follow US-like system, like where political affiliations are there of judges. But we saw by the conduct, what we studied, that there was a political affiliation. And then as per Article 124, we mandate that parliamentarians should be the one who actually decide the fates of these judges. So how do you see the peculiar case of Justice Henry? That was, we never saw how that should happen. Article 124 is really clear on this, that Parliament should be the ultimate body. We should actually decide on cases of proved misbehavior or incapacity. How these proved misbehavior, the word, the sort of these two words have been used, how that can be defined, like the interpretation is still very wide and open. And then we are talking about judicial review of these things. Like somewhere, don't we need to stop ourselves that everything is going into the judicial like side? Like Article 124 mandate is really clear on this, that Parliament should be the ultimate one deciding. But again, you only pointed out that judicial review should be the option on the grounds and all what 1995 judgment you were mentioning about. So how you look into all these aspects?
I want you to just clarify one more thing before I answer your question. Because you are asking this question with reference to Justice A.N. Ray.
Yes, sir.
I want to understand precisely what is the misbehavior in the constitutional context of Justice A.N. Ray, which could or could not have been dealt with by this process. Now, what is publicly known? So, the year I entered Law College, Campus Law Center, 1973, was the year of supersession of judges. And when I passed out in 1976 and joined the bar, Chief Justice A.N. Ray was the hugely unpopular Chief Justice of India. So, you may say that he favored the regime of Indira Gandhi in many ways. Would that still amount to misbehavior for anyone to have contemplated his impeachment at a particular time? Because the judiciary itself has held, in its own context, when judges pass wrong judgments, sometimes district judges pass totally wrong orders or magistrates pass wrong orders, then the High Court initiates disciplinary inquiries. And then the superior courts come to the rescue of the judges that wrong judgments can always be set aside. But that is not a ground for removal, dismissal, etc. So the fact that Chief Justice A.N. Ray had bent over backwards could not have led to his impeachment unless there was an additional allegation of corruption. Is moral corruption or intellectual dishonesty equal to misbehavior? That's a question on which you said you're an LLM student, right?
Sure, sir.
Can you please write a paper on this?
Sir, sorry, sir. So just follow up, sir, on that.
After the discussion also.
Good morning, sir. This is Shreya Dikshit from LLM IBL and first year. And you have talked about the retirement ages of the judges in our country. So there is a bar to certain age they can be judged. Other than after that they retire.
But I haven't talked about it, right? It's there in the Constitution. But
No.
get to your question. Yeah.
Yeah, sorry about that. So I'm just asking that in America, as far as we know, that there is no exact retirement age of the judges, but in India we do have that. So what is the thing that works there and something that doesn't work here? What is the take on this thing?
Can I give you a non-professorial answer? Now I'm just a practicing lawyer. Okay.
That would be okay, sir.
I think it's just as well that we have retirement ages. Right? Because, and that's my quarrel with some of my seniors in the profession, like Mr. K.K. Venugopal, late Soli Sarabji, late Fali Nariman. Every time a judge retired, in their farewell speeches, they'd say, 65 is no age to retire. Why should judges retire? We need their talent for the country. Let's remember, and I'm saying for all of you who are going into litigation, ultimately, there are good judges and there are bad judges. So in the case of some judges, we are marking the dates on the calendar, right? And hoping that they would retire. It's a different thing that in today's day and age, 65 may be an unrealistic age. Maybe there is scope for increasing the retirement age to 70, not just for Supreme Court judges, but for High Court judges also. Earlier, High Court judges retired at 60, while Supreme Court judges retired at 65. Then it was increased from 60 to 62. There has been much discussion on this as to why there should be a differential between the two retirement ages, because both are constitutional courts. And if High Court and Supreme Court judges' retirement ages are made the same, then there'll be less scramble and lobbying for people to reach the Supreme Court. But yes, 65 in today's context is unreasonable. And look at the retirement ages in the past. My grandfather retired from the railways at the age of 55. My father retired from the railways at 58. All this seems so unfair to them in retrospect. But yes, increase the retirement age, but I don't think a life tenure is a good thing at all, even in the case of the United States. And I'll give you one example. Now, we all, at least people of my ideological persuasion, have all admired Ruth Bader Ginsburg. But she stayed on longer than she should have, because she may have had the capacity, but she was growing older. Obama, because in the American system, after all, a president nominates and a Democratic president is likely to get through a person of similar ideological persuasion, and the other way around. Obama hinted to her that she should retire so that that seat could be filled by him with a judge who will then have a long tenure of the Supreme Court. But she chose not to step down, doing a disservice to the institution. So I think there must be a retirement age. Choose your age, 70 to 75, but there must be a time when people should go. And on a lighter note, I sent a message to my friend Dushyant Dave, who called it a day at 70. I said, congrats, hats off to you. I had set myself the age of 72, which is next year, because I'll complete 50 years of practice. But I said that because I was out of practice for personal reasons for 3 years, I've extended my own retirement age to 75, that is to 2029. But I think we should all have some age in mind. And when I was messaging Dushyant Dave, dramatically this offer from Professor Sri Krishna Deva Rao came virtually around the same time. So I know what I will be busy with. From mere lectures like this, I'll apply my mind more and do credit courses and correct papers.
So, good afternoon, sir. My name is Karthike. First,
Who's asking now? You?
so good afternoon, sir. I'm from the LLM batch and my name is Karthike. So first of all, thank you for your valuable insights. So my question is in reference to Justice Soumitra Sen and Justice Dinakaran's case. We have seen time and again that there is a practice, there is a tendency amongst the judges to resign in anticipation of a successful impeachment motion being moved against them. And this leads to, in fact, the matter being down and dusted. So, and also coupled with the fact that in the Veeraswamy case, it has been mentioned that judges, although are public servants under the Prevention of Corruption Act, but there has to be a prior sanction from the Chief Justice of India in order for a FIR to be moved against them. So, sir, don't you think so that by the way of a resignation, it is leading to a de facto evasion of accountability on the part of the judges? And what do you think so should be the mechanism to uh, say avoid this?
Okay, good question. We'll take the next question and
So, my question was that you mentioned in your speech lecture that it's a messy situation in the sense that there's an in-house inquiry and like how it might have conflict with the parliamentary-led procedure. So, my question is what is the solution to like this messy situation or the current situation, and what is a way forward? Like, should there be an amendment to the Judges Inquiry Act to also incorporate a parliamentary procedure in the sense of in-house inquiry and to grant greater sanction to that procedure? Because as you gave an example that the two-third in the case of V Ramaswamy, wherein the Congress parliamentarians abstained in order to not meet that two-third criteria. So there is a possibility of misuse of parliamentary procedure as well, just as in the case of in-house procedure. So how can, like, what is the way forward and how to rectify this situation?
thank you. I think there are two very good questions. Not that the other questions weren't good. Each one has been really stimulating. But to your question, whether anticipatory resignation leads to defeat of the concept of accountability, my answer is no. Because, as you yourself said, with reference to the Veerasamy case, Prevention of Corruption Act is there. Prevention of Corruption Act is there. So all that is required is the sanction of the Chief Justice to prosecute. That is as far as corruption is concerned. But then your question has made me think. Let's take a case of sexual harassment by a judge, which also leads to a possible impeachment. And then the judge resigns. The judge's misconduct on that front is not of IPC standard or BNS standard, but still is a grave impropriety. What happens then? Then perhaps you're right. Then the judge escapes without accountability. And as far as your question is concerned, yes, what solution do I have? That's the hardest question to ask a practicing lawyer. Because the lawyer can only exploit problems and say these are the problems. But more seriously, there is scope for amendment and reform in various ways. One, there should be a concept of lesser punishment also for even the superior judiciary. If you can have it for secretaries of the government of India, why can't you have it for judges also? That is something which can possibly be thought of as part of a judicial self-regulating mechanism without bringing in the parliamentary process. But now that you have mentioned it, that lesser punishment should not be punitive transfer under Article 222. Because how many times we have seen that judges have been pushed to one favorite region of the country. How many times the Guwahati bar and later the newer Northeastern High Court bars have passed resolutions saying Northeast is not a dumping ground. Then secondly, this other thing which judges have devised, saying we will not allot judicial work to this judge until he's cleared. What's the big deal? I mean, if you have the concept of suspension, okay, then you're suspended from work. You'll be given subsistence allowance. If the inquiry is not completed in 6 months, that subsistence allowance will be increased from 50% to 75%, then to 100%. But not giving judicial work is no great remedy. The judge is drawing a salary here, the cost of the public exchequer, and he's doing no work. So how are you solving the problem, or how are you disciplining the judge in any way? This is totally against public interest. But also I agree with you that this 2/3 majority may be something which needs review. Because if you have the Judges Inquiry Act with judicial personnel manning the inquiry, and so there is an assumption of basic fairness, then why 2/3 majority? Why shouldn't it be a simple majority? That's something which ought to be thought of for the future.
Okay. Malvika, do you want to just come in with your final comments on this?
Sure, sure. Thank you, Mr. Ramachandran. That was so illuminating. And as Anup said, even I hadn't thought of it in this way. And I've also read your work, so this sort of gave me a lot of clarity on concept. So just to anchor it back to Charles Black, I think what we learned from you today is that the two principles that you can extract or extricate from the Constitution's text in Article 124 is judicial accountability and judicial independence. And you are also drawing these principles from the structure and relationships encoded in Article 24 between the executive and parliament on the one hand and the judges of the Supreme Court on the other hand. And the other thing that I observed today is that you're contrasting this regime with the pre-constitutional regime to sort of draw meaning what these principles could be. So the key insight and learning from this talk for all of us today is that the relationships laid down in the Constitution can either be in a creative tension with each other. As you said, they could act as checks and balances on each other, or in a mode of one-upmanship, which is what has happened in the Justice Yadav and the Justice Verma situations, it appears. And if if there's a grabbing of turf, as you called it, between the two organs, then that might well do great violence to the principles of both judicial accountability and judicial independence. So I think that sort of conceptual clarity was extraordinary. So thank you very, very much for this illuminating talk. Before we close, I just wanted to share a few housekeeping points as we go forward for the rest of the lecture series to the students in the audience. We will share a few readings for this lecture as well as the upcoming remaining lectures through Professor Surendranath to the student body. The next lecture will be, of course, on September 27th. So there's some time for you all to be able to read everything shared and also prepare for the rest of the lectures. Mr. Ramachandran will further explore this sub-theme in his first lecture. The sub-theme is structure of constitutional offices, or the relationship between constitutional functionaries. And the second lecture in this sub-theme will be the role of governors in light of recent controversies. Future lectures will be on two other sub-themes. The second sub-theme is the structure and relationship between the Union Parliament and the Supreme Court when it exercises judicial review. And in that theme, we will be exploring Sir's critique of the basic structure doctrine, which he intends to revisit, as well as Article 143 from Justice Fazal Ali in In-Re Delhi laws to Justice Pardiwala in the Tamil Nadu governor's case. And the final sub-theme, which comprises the last two lectures, will be the relationship between the state and vulnerable groups of individuals, as well as inter-se relationships between such groups. And in that theme, he'll be covering a lecture on the reservation controversies of late, both covering EWS as well as subclassification of the scheduled castes and scheduled tribes. And finally, decriminalization of homosexuality to be read in sort of contrast with the marriage equality case. So this is the lay of the land as we go forward, starting 27 September. And then the lectures, as I understand, will be in quick succession. So it'll be good for the students to have read materials in advance in the time that we have now. That's all from me. Thank you so much, sir, for this opportunity, and to Nal sir for letting me join on this teaching assistantship.
Sherpa. Sorry, with Professor Surendranath's permission, I just wanted to say one more thing. That since this lecture was fixed at short notice, I had to use something which I have already written. So my talk today is based on a chapter which I have written for a book written, edited by Justice S. Muralidhar on 75 years of the Supreme Court. I told Justice Muralidhar that if he allows me to use my own article in this talk, I will give free publicity to his book. So this book was released only yesterday, Juggernaut, Incomplete Justice, in within brackets, Complete Justice, 75 years of the Supreme Court, published by Juggernaut. Please watch out for it. I think it'll be worth reading because these are critical reflections. But I must also tell you, as an aside, that there was a separate publication by the Supreme Court to mark 75 years, which was brought out by the Supreme Court during the Chief Justiceship of Justice Chandrachud. So there was some exhilaration and some disappointment also. I was one of those who was invited to write for that. There I wrote on freedom of conscience because that's the subject which Chief Justice Chandrachud gave me. Here Muralidhar asked me to write on independence of judiciary, and many advocates, senior, not so senior, were invited according to their domain expertise to contribute. And I wrote back to Chief Justice Chandrachud very excitedly, saying that this is an honor. And because I was associated with the volume on 50 years of Supreme Court, supreme but not infallible, which the Supreme Court brought out through Oxford University Press. I said I was asked to contribute there. So 25 years later, to be asked to contribute to 75 years of the Supreme Court, I feel really honored. And so did all of us other co-authors. We all patted ourselves on our backs and thought how good we were that we were invited to write. But this, I'm just talking of something institutional. Project, apparently none of the other judges of the Supreme Court were aware of. So on the last day of the Chief Justice's retirement, this was released along with a function where other things were released. Not many sitting judges were aware of it. The publisher was Thomson Reuters. None of us contributors got a copy of the book. Finally, after waiting for 6 months, I ordered my copy on Amazon, but Muralidhar edited book will be freely available. So please buy it. Thank you.
I thought also the Supreme Court's publication 75 years is so emblematic of how the court thinks of these issues that the number of academics writing in that, there are barely any, right? And I think, yeah, I think there are only one or two, I think. And I think that reflects so much of the way the court thinks of what it needs to learn or hear from academia as well, for sure. But thank you so much, Mr. Ramachandran. I think, and the framing that Malvika provided of structural reasoning is so important, and the thread that you maintain throughout your talk in terms of what are the institutional relationships in play in the impeachment proceeding, and the delicate balance, particularly given how appointments, the law on appointments has been developed, the balance that you are referring to, and the tentative delicate balance that there is, and the need for the judiciary to respect that, I thought is very thought-provoking. And I think and the importance of moving beyond doctrine to look at structure and look at these questions from a structural perspective was really illuminating. Thank you for that. I also just want to thank Professor Rao and Professor Vasanthi for facilitating this and in such a timely manner, and having you be a part of our academic community. And I think that's so important for academia and the bar to cross those bridges in both directions. And I think there is much work to be done there. And is a relationship that has not sufficiently been nurtured and built. And I'm so glad to see this happening. So thank you to both the Vice Chancellor and the Registrar for facilitating this. May I just call on the Vice Chancellor to give this token of appreciation to Mr. Ramachandran, please. Ma'am, please.
Thank you. I've started a new career.
So thank you everyone for joining us today on a Saturday, and we look forward to your participation in the next series of lectures starting September. Thank you and have a good weekend. Thank you, sir.